Hey, thank you for following directions and getting back here expeditiously. I think we are on time, but my task is to keep us on time so we can certainly move to the keynote presentation at noon. In preparing to moderate this panel, I started where most research starts these days and where unfortunately most research ends, Google. So I Googled, as it was, the title of this panel. What is the best way to educate judges? The first entry was from a site named educationportal.com, and it provided the following 6 steps to become a judge. Step 1, attend undergraduate school. Step 2, earn a law degree. Step 3, pass a bar exam. Step 4, work as an attorney. Step 5, obtain a judgeship. Step 6, complete training. And in that last step, it stated, under this last step, after being elected or appointed, judges may be required to complete a state-administered introductory training or attend training programs led by legal organizations, such as the ABA, National Judicial College, or National Center for State Courts. The Federal Judicial Center provides training programs for federal judges and other federal court personnel. So, and it is this part of becoming a lawyer that this last panel is about, sort of the process of educating training and what training is required. In the respective countries, our panelists are involved in this very process, the process of training judges, and today that is what they will be discussing. I will introduce the speakers now, and then let them present in the order they appear in the program. They will have 20 minutes. I will be giving them time warning so we can keep on task. Dr. Livingston Armytage currently serves as the director for the Center of Judicial Studies in Sydney, Australia. He's also an adjunct professor at the law school at the University of Sydney, and he's a visiting fellow at Cambridge University. He has over 40 years of professional experience working on issues of justice and judicial education. He has served as senior counsel, project director, and team leader in a variety of countries, and he has presented his work at places like Harvard, Oxford, Cambridge, UC Berkeley, and he can now add to that list Missouri. Professor Dawson teaches at Carleton University in Canada and serves as the academic director for the National Judicial Institute. Her research explores the links between judicial education and judicial process, in particular the development and scope of social context education. Her work draws from her experience in Canada with the National Judicial Institute, in Ghana, doing a strategic development of judicial training, and in the Philippines doing judicial mediation. Her research focuses on the use of experiential learning methods and implementation of peer learning in professional judicial context. Judge Jeremy Fogel served as the district judge in the U.S. District Court for the Northern District of California. He was appointed by President Clinton in 1997. Before that, he served as in Municipal Court and Superior Court of Santa Clara County. More recently, Judge Fogel became the director of the Federal Judicial Center, which is actively engaged in judicial training. So I will then now turn the podium to Professor Rafael.
Thank you.
Thank you.
I'm going to present from back here because I've got to manage the keyboard, but I hope you can see and hear me. So in this session, I'd like to start by thanking Stacey and Rafael in particular for bringing together this, for me, unique experience where judges and academics look at researching and more systematically developing knowledge in this area of judicial education. There are very few examples of this around the world in my experience. Now, in the next 20 minutes before I get the cattle prod, what I wanted to do was to present to you an argument. I'm framing this argument as potentially a provocation. The provocation is that I want to challenge and expand prevailing notions of what the purpose and the vision of judicial education is. So I'm presenting an argument and that is that it's not sufficient for those of us involved in judicial education to be concerned with the pursuit of professional competence, difficult and challenging as that is. We also have a professional responsibility to actively promote improvements in justice. When I was preparing this presentation, I thought that this would be provocative, and I perhaps hope it is. But listening to Professor Bob Bone, to Kathleen Mahoney, and also Chief Justice Russell, I'm not sure if this isn't in fact a return to the way things might have been in the 1960s, at least in the way you, Bob, framed it in, I thought, a very galvanizing way. So in order to contextualize my argument, what I wanted to explain briefly is that I started practicing law in Australia in 1974, and then through a number of reasons became involved in professional legal education, and then to my own surprise, the education of judges at a time when that was very new and quite controversial in Australia in the very early 90s. In order to educate myself, principally, I did a dissertation which was ultimately published called Educating Judges. And in due course, after about 15 years of working in international development, I did a doctorate which was published as Reforming Justice. And in today's presentation, what I really want to do is to bring together these two bodies of research. And I've made a note there that I'm presently updating my research on educating judges, but at 2 o'clock this morning, when I was grappling with my jet lag, I decided that in 20 minutes I don't have the time to talk to that research, although it is in the PowerPoints, and I think it will be part of the conference materials. So in 1996, when I was seeking to cohere what this new body of judicial education was all about, both for myself and the judges that I was seeking to persuade as willing participants in this controversial activity, I went back to research the history, and Professor Bone has in fact digged more thoroughly than me. I thought it was Chief Justice Warren Burger in '63 that really planted the flag to launch the judicial education ship here in the US. But you correct me that it's in fact at least 6 years before that. But certainly as a part of developing a notion of judicial education, I found that the judiciaries, and one of the reasons why judicial education was important, was because it needed to grapple with challenges and to public credibility and trust in the institutions of justice. And the sort of thing that Kathleen was talking about with gender bias was something that the judiciary around that time was acutely vulnerable to. Not just gender bias, but racial bias, and basically that the judiciary was out of touch with the community that it aimed to serve. And this was something that was exploding all around the common law world. In my jurisdiction, Australia, obviously the US, Canada, UK, and these were really the focuses of my research at that time. So I looked at the relationship between judicial training and the institutionalization of that process, and recognized important links that the judiciary found education important and compelling at that time, because it demonstrated to the community that it was concerned with quality. It was in fact a mechanism for accountability. And in the process of embarking in judicial education, those of us that were doing that needed to give a fair amount of very deliberate thought to formalising what the goals and standards were of judicial education. What were we trying to do? And indeed, in my research, to legitimise and make respectable this idea of educating judges, which a lot of senior judges thought was little short of ridiculous at that time. And one of the big changes is that senior judges no longer see that as ridiculous, and the judicial leadership in fact sees judicial education as a professionalising mechanism. So the argument that I put at that time was that the main purpose of judicial education was the quest to pursue this idea of competence. And competence was a relatively new concept for the judiciary, not because it was incompetent before that, but just to frame the idea of competence as a lens with which to assess the legitimacy of the judicial arm of government. Now, the idea of competence is integrally linked to the idea of performance. Performance of individual judicial officers and institutional performance of the judicial arm. And I want to frame that because that was recognised back in as early as 20 years ago, but it's still a controversial link. The linking of training and visible performance gain is something which I am posing here remains controversial and difficult for judicial institutions to deal with because it deals with issues of measurement and how best to do that. Sensitive, complex issues. Now, the argument that I put in essence was that the business of educating judges is a very distinctive and indeed, from my point of view, very fascinating exercise, but that to make it professional and to do this seriously, we needed to build an argument, a relationship between the general body of education and the more refined body of adult learning, and then the more further refined body of professional, continuing professional development. And this logic was necessary because judges, many of them found the idea of education and an assumption that they were going to be treated like children insulting for obvious reason. So I needed to conceptualize a different model, which was clearly not a child learning model, and built around a facilitated learning model and the sorts of ideas that Bob was talking about in terms of critical reflection. So this model involved, it was based on the basis that judges are distinctive learners. And there's a number of reasons for judges being distinctive learners, which are important to any of us involved in facilitating that learning. And these reasons are up on the screen. Social and doctrinal reasons relating to the process of selection, the role of judges in our society, and the need to consolidate and respect independence of that office. The second cluster of reasons are educational, relating to what I should admit is scant research on the learning needs, preferences and styles of judges as an occupational group for their learning. And I frame that really in the last proposition, the professional reason, and that is certainly in the Australian courts and in the courts that I was working with, judges epitomise very successful self-directed learners. And that's an important thing to recognise, because if you don't recognise it, it's likely that you're going to offer education that may damage the intelligence and also the willingness of judges to participate. It's important to engage a process that is appropriate for those that are involved in the learning. So I was very interested in this idea of moving beyond competence, looking at what Donald Shern describes as professional artistry, and it's the sort of thinking that Donald, I think, may have been referring to. So obviously we need to build substantive knowledge, problem-solving skills, and professional attitudes and outlook, the sort of thing that I know that Canada has been excelling in, social context education. But in fact, a lot of these ideas are integrated in the idea that I find compelling of professional artistry. And that was sort of some of the ideas of tacit knowledge that you were talking about this morning. I think we're talking about the same thing with different words. And in the process to develop a policy framework that found a balance between individualised learning of very successful self-directed learners, but also a peer-based process so that there could be critical reflection. My goodness, and there's only 10 minutes left. And in addition to that, to develop an evaluative process to assess the success of that exercise. So this was the proposition that I put back in 1996. There is a need for a distinctive approach to continuing education, which builds on the foundations of professional and adult learning, but more importantly addresses the specific needs of judges. And that argument I assert remains robust 18 years later. But then, in a second body of research that was published by Cambridge a couple of years back, which reflected my ongoing professional journey as a justice reformer, I put this argument, and it's a separate argument, but let me go through it quickly. This argument was a critique of the experience of promoting the rule of law around the world, mainly in developing jurisdictions, and particularly in my area, Asia, over the last 50 years. And this critique built on the premise that justice is core to any notion of a good society and to any conceptualization of individual well-being. And it flows from that, obviously, that courts are the key agency of the state in order to administer, protect, and promote the public good of justice. So all of that is so far so good. The problem is that the courts are often characteristically under-effective, and I use the word under-effective in quotes. Sometimes I use other words depending on which country I'm working in. They are under-effective or irresponsive to delivering this public good well. And the usual reasons in developing jurisdictions relate to lack of access, inefficiency, unfairness, inequality, the sorts of things that Kathleen was talking about, lack of resourcing, corruption, and impunity. And the reasons why reform to deal with these problems has been, in my experience, extraordinarily difficult is not just path dependency, but political economy. The reform efforts are actually blocked by power elites who, in fact, benefit from the state of disrepair of the judicial arm. Now, the consequence of this state of affairs is a generalization which may or may not be controversial. Most citizens around the world are marginalized and operate beyond the realm of the rule of law. Now, let me say, this is not just a generalization that I offer for places like Afghanistan, Pakistan, Cambodia, Papua New Guinea, places that I do a lot of professional work in. When I've done my work there, I come back to my country, Australia, and I make the same observation. I make the same observation. That the courts are struggling to administer justice in jurisdictions around the world, whether those jurisdictions are developed or undeveloped. Now, this is not a novel problem. In my frame of reference, development agencies are spending literally billions of dollars grappling with the problem. USAID, the bank, UN, and so on, my country, Australia. But the difficulty is that the results are characteristically anemic, if not invisible, that this is very difficult work with very limited impact. So limited that the major multilateral development agency in my part of the world, Asia, the ADB, after 18 years, retired hurt from the endeavour. After having spent over $1 billion, when they evaluated it, and I sadly was involved in the evaluation as an external expert advisor, they found investing in promoting the rule of law under-competitive to putting in hospitals, schools, sewerage pipes. So they backed up. They didn't say that. They said they were mainstreaming the promotion of the rule of law. But that's code for this is too difficult. So we are poised on the chasm of what I would describe as development failure. We have a situation where justice is fragile, and in some of the literature it is described as a failure of justice, and we have a problem of reform under effectiveness. Now this leads me to the current imperative that we as educators must recast our role when we look at supporting the courts through judicial education. There are a couple of handouts that Stacey's going to hand out now, and I've got about 3 seconds to speak to them, but let me talk very, very briefly. This is a World Bank diagnostic based on a great deal of information, about 25 different data sources on the rule of law health of the United States. Now, I would normally start with the rule of law health of my country. And I would make the point, there are problems in my country. The problems in my country is that justice is unequal, particularly for Indigenous people. It is slow, and it is extraordinarily expensive. So basically, the middle class has been marginalised from access to justice. It's not just women in my country, it's certainly women, but it's everyone. Unless you are a large corporate, or unless you are someone charged with a criminal offence where there'll be a lengthy prison sentence, you will probably not be able to afford to use justice. Now, the situation is broadly the same in the US. Maybe marginally better, maybe marginally worse. You're in the top 10 percentile. And of course, this is an aggregate score, not of a particular court, but of perceptions of the justice sector. So far, so good. That looks quite good. You're in the top 10%. There is, however, a new data set, which is much more nuanced and provides much sharper measures. And this is the data set that you will not be able to look on the screen, and that's why I've given you the handout. Now, this data set is produced by the World Justice Project, and it ranks the US at 19 out of 99. So you're in the top 20%, not top 10%. This data is much more precise, but I want you to assess in your own time whether you find this data credible. And it's up to you to decide that, because if you find this data not credible or not fair, then you should disregard it. But what I do with data like this is I look at the things that I know, and I look to see if the scores are strong or weak. Now, it's for each of you to decide that for yourselves, and this is aggregated across all of the courts of the US. But let me turn quickly to a couple of measures. So if you look up here in the top left, and you won't be able to see it on the screen, but you'll see it on your sheets, you'll see there's a reference to absence of corruption. And broadly speaking, America is less corrupt than more corrupt in terms of the arm of government. So that's generally a positive score. Let me go over here, 7.3. 7.3 relates to the absence of corruption in the judicial arm. Now, it seems to me, very good news, and from what I know of the American justice and court system, that is credible and that is an accurate measure. Now, if you accept, just by doing your own checks, that this data set in what I understand is called the spider graph is credible, then what I would invite us all to do as Chief Justices, as justice reformers, or as judicial educators, is to look at those areas where there is a poor score. Now, the way you do that, where the graph, and the US is the black line, where the graph is out on the outside, that's a strong positive score. Where it's tight in the middle, it's a negative score. And you can see that the US scores pretty well against other comparable economies. 1 minute left, I can't believe that. But let's have a look at a couple of the bad scores. So if we look at, it's down here, 4.1. 4.1 is equal treatment and the lack of discrimination. So this data set is saying that equality of treatment and discrimination is problematic for the justice system in the US. You may or you may not accept that, you may or may not find it credible, but this is an aggregated data set that suggests this is a problem. Let's look at 4.3. 4.3 is due process in law. I'm not sure exactly what aspect of due process, but it's saying this is a weak score as well. Let's move across to down here, which is 6.2. This is order and security, a very strong score which relates to the absence of civil conflict. That's great. There's, apart from a few unfortunate incidences that may arise, you enjoy a very peaceful community. But let's move around to some of the other scores. So number 2.1. 2.1 is no corruption in the executive, and 2.2 is no corruption in the judiciary. Those are good scores. But let's look at criminal justice up here. Effective correctional system, well, there's obviously problems according to this. And 8.4, no discrimination. There's problems there. 8.7, due process in law is quite a low score. If you go across to civil justice in the 7s, 7.1, accessibility and affordability is a weak score. 7.2, discrimination is a weak score. I want to offer that to you as a supplement to the data collection. We had a paper from Diana Richards yesterday looking at judicial surveying. We had another paper from our Canadian colleagues on surveying the judiciary. Surveys are very useful ways of informing what the needs for judicial education are. But I generally, in my experience, find an underuse of hard external data for informing and driving and defining what the needs for judicial education are. This data set, in particular, the World Justice Project, is, I think, something that you might find interesting to look at, because it's a new data set. It's got a vast amount of information. So taking this argument, let me just move as quickly as I can to the role of, and the cattle prod's about to come out. Stacey, can I negotiate just for a minute?
2 more minutes.
Thank you. The role of the judicial educator should not be to focus on competence being the problem. Competence is not the problem, delay is not the problem. These are symptoms. And accordingly, in my argument, technocratic solutions are not going to be sufficient. They're necessary but not sufficient. The real need that we need to address here is leadership. And Andrew at the back there, I think, may be happy to hear that. The real challenge is leadership. To see judicial education as being an agent of change. That we as judicial educators should be focusing on enabling the courts to perform their constitutional role, to deliver services that respond to the needs of people, and to promote access to exercise rights in law. In other words, we need to innovate a relationship between judicial education and judicial reform. Now, once you think about that, the questions that should agitate our thinking are altogether new questions. The questions are, how can educators help courts to improve performance? And not just what should we be promoting in terms of competence, but competence to do what in particular? How can justice service be improved? And how can training results be measured? So this is in fact an argument that links a number of key ideas. Training to competence to performance to improved justice outcomes. And I can assure you in practice, this last one is never done. It's not done because it's difficult. And I'm posing this as part of my provocation. This is the boundary that we need to press onto. So I wanted to frame a comparison in the two visions since 1996 and 2015 or 14. So this is the old vision, and it's the vision that's really preoccupied with educational effectiveness and the pursuit of competence. And the new vision, which I'm arguing we must adopt, is that yes, we still build on educational effectiveness, but we must aim to address the justice needs of citizens for whom the courts are constitutionally mandated to serve. And we don't do that enough at the moment. So the vision for judicial education, as I have argued, is that we have a professional responsibility to take an active role in promoting justice and not just promoting competence. Thank you.
I have obviously no quarrel with Livingston's vision, but my talk will be more internal to judicial education, and it will focus on pedagogies for effective judicial education. Now, I'm the Director of Education for Canada's national judicial education body. We design, deliver, work with courts and national programs for really most of the education that judges in Canada have access to. And I've been involved with judicial education intensively for the last 15 years and see it as a meeting point with judges as they navigate complex roles and endeavour, indeed, as Livingston has so elegantly put it, to deliver justice. So our curriculum is organised around three main areas: law, craft, social context. We've been developing a fourth dimension, which resonates very strongly with the material we began today with, judges and judging. So we're really looking at knowledge and skills and awareness, but also in developing that critical reflectiveness and having judges themselves identify and deepen their understanding of what it is that judging is, how it's conducted. What's on my mind these days in my role? Well, I'm interested in how we can improve progression of learning, how we can ensure that we have an integrated portfolio of education between self-learning and electronically assisted learning and face-to-face learning. I'm interested in an overall e-strategy, so much so good. But the last one is I'm interested in how we can foster and facilitate a partnership in creating a centre of excellence on judging for judges, but in partnership with academics. So a conference like this, and I echo everybody's thanks to you, Stacey, and to the University of Missouri Faculty of Law and Dispute Resolution Centre, in helping to foster those conversations of which today is a part. Now, I'm also a law professor, and so my work with the judges and my work in my teaching has really sharpened in me a sense that pedagogy matters. And by pedagogy, I'm really talking about how we approach teaching and learning, and I think it's guided by how we understand it, and the theories which make sense of it, which in turn then direct how we design and deliver it. So the questions which I undoubtedly won't get all the way through this morning are, well, what kind of learning is judicial education? How is it best conducted in terms of design, teaching, pedagogy, and just how can we make that happen? Now, we're familiar with the idea that there are different kinds of learning settings. The setting we're in today is sort of an example of learning by listening. Now, that's a lot of fun for me. I put a lot of work into thinking about how I can crystallize and distill my thinking, but unless you get a piece of paper or you're making notes which you refer to in a few days, you'll forget most of this. But it's useful for me because I've had to put some ideas together. And these events are ideally to sort of stimulate thought, to get synapses firing, to create new neural pathways which we then expand. Arguably, judicial education, which is learning by listening, won't take you very far because, well, we forget things. And I'll give you a slide in a few minutes about that. There's learning by observing. And so this is the opportunity to see other judges working, for professors, to see other professors teaching, the presence of mentors and shadowing. There's a convention in Canada that judges don't sit in one another's courts. There are limited court shadowing that, if it's that new judges do, but often the last time you see a judge is the last time you're a lawyer in front of one. So there's plenty of room to expand this area of learning by observing. The last one is learning by doing, getting your hands on things, connecting concepts to practices. This can be done in the workplace, obviously, workplace learning, but also in education settings which endeavour not necessarily to simulate the workplace, but to be about the work and to help judges to engage with what it is that judges do and how they do it. So my argument really is that I can just tell you, at NJI and in Canada, we've adopted the learning by doing model as the most appropriate sort of overall approach to judicial education. So then there's a focus on skills development, there's a focus on developing critical reflection in our work. And this is animated by the idea of experiential learning. Experiential learning is almost the same thing as saying learning by doing. Learning by experiencing, immersing in the subject matter. So one of the first things I want to talk about in this regard is a key concept is a learner focus rather than a teacher focus. And this is very hard for us as professors to kind of really believe in, because don't we get paid for being the expert and focusing on us and assuming that our listeners are also focusing on us. So here's an interesting slide, and I told Jeremy I was going to show it so he didn't have to. Retention of learning. And this slide tells you almost the whole story about learning, experiential learning. Retention of learning. If you just listen to the lecture, and I'm giving some audio visual, so that'll move us up a little bit. I had to cut out any of the doing parts of this because of time. And you see that the person who's learning the most this morning is me. And I remember this most because I'm teaching. So it's that, there's the problem with learning by listening. And this is sort of the goal to get retention up here. There are some studies that kind of confirm this slide. One I particularly like is done in the University of British Columbia with a large first-year physics class. A module of the course was subject to experiment. Now the course was divided in half. The members of the course in Section A and Section B were the same. They had the same profile, they'd been coming to class at the same rate, whatever it was. Section A was going to be taught this module by a charismatic professor with experience, teaching awards, he'd use clickers, and Section B was going to be taught by an inexperienced postdoctoral fellow. Never taught before, wouldn't lecture, would give students some things to read before class, and start off with a few clickers, talk about them, show a demonstration, then put up to the question and have the students talk with themselves before they answer the clicker question. And then they vote again on the clickers. And that was basically how it worked. Now, of course, this was slower, it took longer. The postdoc didn't even get through the syllabus, 10 or 11 of the 12 topics. So the question is, it came to examination time. So which section of the course do you think did better on the common exam? Now, you're thinking this is a trap. Professor Dawson has just shown us that retention slide. Oh, that doesn't really relate to this, does it? They were clicking away. And I'm picking that you're kind of, you're picking that I'm kind of nudging you towards the postdoc section. Why would I be telling you this story? But I'm sure that in your heart of hearts, you're pulling for the professor. Right? The judge in the room isn't that a judge in the room. So you must think, well, maybe the postdoc didn't completely bomb things, so maybe it's close enough. Well, here's the results. Students in Section A with a charismatic, experienced professor, well, they scored 41% on the exam. They bombed it. The students in the postdoc section scored 74%. 74%. One failed, one did really well. So it's kind of stunning. Judges who hear the story, even though it's published in a reputable journal, Science magazine, Science, they don't believe it. Judges are different. Judges listen all the time, they learn by listening. But here's my other favorite slide at the moment. So I'll give you a moment to look at it. This is a study they hooked electrodes on to students as they were going through their week. For a whole week, and I can only fit 5 days on the slide, but you probably only need days 1, 2, and 3 to get the message here. So what's happening here, they're in a lab with doing stuff, they're studying, sleeping, dreaming. Look, dreaming is the most active time. Turns out. And here's, if they've got homework to work on, day 1, day 2, they're still at it. Chores, yeah, the dishes don't really do it. TV, look at TV, whoa. But look at this. Class. In class, listening, students are flatlining. So learning by listening doesn't cut it. So that's what we do. There's another study, I'll mention it really briefly. Same lecture given to be delivered by two people. Charismatic lecturer, and somebody stumbles and hunches and doesn't articulate very clearly. Evaluated at the end of it. Reaction evaluation, did you like it? And then did you learn the level 2 on evaluation. So of course, the people who were in the engaging lecture, they enjoyed it a lot. And the people who weren't, good. But their learning outcomes were basically identical. So what's the explanation here? And Eric Mazur, who's done some really innovative work in this area, says, well, the key trick to this is that, what he says, with a better presenter, it may seem like you're taking more in, but it doesn't mean that anything has actually been learned. And doesn't mean there's been an aha moment, he said. The hard work of learning has to be done by the learner. Right? There's not much that the instructor can do to make the neuro connections for learning. So the first lesson of experiential learning there is to focus in on the learner, and it's what the learner is doing, and the learner needs to become the focus. Now, Livingston sort of adverted to the journey of judicial education, which has been to adopt adult learning, the idea of learners being adults, becoming the second class of lecturer. Adults are self-directed, goal-oriented, relevancy-oriented, and practical. They want to be respected in the learning setting, and we've discussed this with judges. They wholeheartedly concurred with it. They've added that, and we've noticed that they won't tolerate education, which isn't directly related to what they do. They don't warm to theoretical discussions or abstract discussions. They're intelligent, fast learners, and they're used to suspending judgment. So they're adult learners. David Kolb's work has told us a little bit more about learning. People come to learning with different learning styles. Some people learn from their heart, some people learn from their head. How we take in knowledge and then what we do with it. Do we reflect upon it? Do we then take action in relation to it? He developed a tool called the Learning Styles Inventory, and you can take this and it'll sort of sort you into the kind of learner you are. Whether you're primarily somebody who experiences and reflects, or whether you're somebody who thinks and does things. One of the insights of his work is that in any group of learners, there will be a mix of learning styles. And this holds true for judges as well. We've done the learning style inventory with judges, and although there's a tendency for judges to be more on the cerebral side, unsurprisingly, there are doers, there are brainstormers as well. So then this has design implications. One of the design implications is that quadrant, that the learning style itself suggests to us that there are different dimensions that need to be attended to in judicial education, in all education. It's not just the head, but it's also experience, which develops, it's also experience, which develops emotional capacity, it's reflection, which develops perceptual capacity, obviously conceptualization for intellectual capacity, but experimentation or application, which develops behavioral capacities. We've been talking a little abstractly about what it is that judges do. Academics tend to think that judges decide things, and that's true, of course, it's a core function, but judges do a great deal more than that. They communicate, they justify, they manage with or without sufficient resources. So all of those dimensions of learning need to be present. If you think that all of these dimensions, and I haven't had a chance to sort of warm the argument up very much, but if all those dimensions need to be present, we have adults, so we have these dimensions of learning, well, how do you do that? Kolb helps us by saying, well, there's a learning cycle or a learning circle that the design of judicial education programs and sessions need to move around. So briefly, the dimensions of learning: experience, reflection, conceptualization, and application. So if you were to put this into design, you would start off with activities which engage a judge based on their past experience, why it is that it's important for them to learn this, put them in a role play, literally to experience from the other side. Activities which then promote reflection, small group discussion. If you don't have time for that, you can use clickers so that judges see that they don't all see things the same way and that there's something to talk about. To observe performance of an oral judgment, of a communication. See a judge in a real court and what he or she is doing over the course of a day. Then you can do your lectures. Make them short, make them related to what it is that you want the judges to be able to do with that information through activities. It could be role plays, it could be problem solving, it could be practicing communication exercises. So that sort of gives you the flavour very quickly of the design sequence. I thought I'd try and make this a little concrete for you. I'm so tempted from all the discussions. Should I talk about our good judgment course? Should I talk about our art and craft of judging course? Should I talk about our social context courses? But I'm going to talk about a charter course. The charter is like Uncharted, Kathleen, you talked about it, kind of like your Bill of Rights, no unreasonable search and seizure, mobility rights, rights to life, liberty, security of the person. 30 years ago, came into Canada, body of jurisprudence developed, and in 2002 the NJI decided, well, it's time for a charter course, an intensive course over a week where we would teach judges the charter, or where judges would learn the charter. So the first thing is, well, our people sat down. I want you to think for a second, based on where you started today, well, how would you design that course? So I'm going to use 30 of my precious seconds to have you think about that. Right? I'm going to time you. We've got 30 seconds to say, well, what would you do? How would you design it? All right, so now what our people did when they sat down is they said, okay, well, what we'll do is we'll go through section by section. So we'll do a morning on search and seizure and an afternoon on mobility rights, freedom of expression, and we'll have some lectures, and then we might have a problem now and then, right? Analysis of the case. And I am thinking that one or two of you might have said that obviously the way you teach the Charter and the Bill of Rights is you have lectures on the relevant sections, and then those lectures will be about the jurisprudential debates of the highest courts of the land. Our people then sat down with an adult education specialist, David Cruikshank, not me, and he talked about some of the ideas that I very quickly run past you, and the course fundamentally changed. The course became a course, the title of it was Hearing and Deciding Charter cases, responding to the anxiety that judges felt when they got one of these cases and they hadn't learned to start in law school. They were often high profile. They changed the way the criminal trial was run. So it was to meet judges with how to manage these cases. And then, of course, you can see that by focusing on hearing and deciding cases, you're bringing them in to what it is that judges do and what judges think about in relation to the Charter. And then the flow of it was that we, of course, began, may not be an of course for you, but we did talk about, well, where did the Charter come from? What are the underlying values? And what is your role as a judge, and how is it changing in relation to this document? And then there was a rolling fact pattern, two rolling fact patterns that went through the week, one on criminal law and one on civil, what we call civil charter. They call it civil charter or equality, if you're pleased to know, the whole thing on equality. So it's a fact pattern that takes judges through the touch points that a judge will have in a criminal case, through motions, through merits, through disposition and remedy. So that's an example of how it went. It's making it happen then. I suppose the challenge I want to pose is, when I told you about the UBC study, did you believe it? When I show you that slide, do you believe it? I think there needs to be a change. I have in my paper a whole series of quotes from evaluations that judges have given us about your experience of this kind of judicial education. They love it, they want more interactivity, they'll point out courses that have been distinguished by interactive exercises and say that they were very valuable. They'll say that some courses have been paradigm shifting for them, a national program on Aboriginal law, which involves elders directly. So the problem isn't our judges and whether anymore, isn't whether our judges will accept that, but how can we sustain this model? So it comes down to who plans and what they fundamentally believe in terms of their teaching philosophy and their teaching style, and whether we will take the risk and devote the time to doing education this way as judges. Chief Justices have been supportive, but they need to signal so that judges get the message that this is actually what's expected and what will be valued, and they also, I think, need to provide the time for judges to do this work. Our role as a judicial education is to maintain the expertise and the support to meet judges in that place, so that we can, if I can conclude, where am I? Oh yeah, this is what I wanted to say. According to the onus is not so much on judges as learners to accept the new pedagogy and learning culture, but it is on those responsible for teaching and designing judicial education to accept the lessons of research and experience and be willing to implement the pedagogy for judicial learning which flows from it. Judges are tremendous students. They work hard, they engage. It's a privilege to meet them in the judicial education setting where they can reflect upon their work at that place where law meets life. But through steady attention to pedagogy and conversations about it, I believe that judicial education can help judges develop their artistry and indeed move from myth to method. Thank you.
Okay, well, Brettel set me up perfectly. The thing that she finished with was exactly where I want to start. And I'd like to join in thanking Stacey, who I had the privilege of working with for a year when she was a Supreme Court fellow, and everyone else here at the law school for hosting us. It's also just a real treat for me to be on the same table with Brettel, Dawson, and Livingston, Armytage. The world of judicial educators is a fairly small one. It's an inside group, and these two have been, each in their own way, a tremendous inspiration to me as I've tried to think about judicial education for the federal judiciary. So it was really great to have this opportunity. The reason I asked that this be put back up was that everyone at the Federal Judicial Center is sick of this chart. It's up all the time. Whenever we have a staff meeting, whenever we plan a program, whenever we talk about where we're going, the retention chart is usually up in several different places because it's a fact I don't ever want people to forget. And one of the things that's interesting about it, this is a light pointer?
The top one is that.
Okay. So I don't know if you can read this. This is the date that this data was first released, 1954. Okay, so this is not some new radical idea that just came out. This was 60 years ago that this was published, and it's been out there for 60 years. But it's still difficult for us working in this space to really get people to believe it. I think part of it is that those of us who were trained as lawyers, this room isn't too bad. I mean, it's still set up with the focus on the man or woman at the front, right? But I mean, some of the law schools I visited, the rooms are really set up as almost like operating theaters. You know, where you have these steep walls of chairs, and then there's the professor down at the bottom. And so the whole shape of the way we think about teaching focuses on the sage on the stage and the expert expounding, and it's very hard to get people to break. That's what people think they want. And then we have these great lecturers. I always think about Erwin Chemerinsky, who many of you know. He's an incredible lecturer. Every time I see him, I just am dazzled by his brilliance and his ability to lecture. But I always tease him. I say, Erwin, they don't remember anything, and they remember how brilliant you were, but they don't remember what you said. So, I think it's hard when you are surrounded, and all of us can probably remember professors we had who dazzled us with their brilliance. And so, it's hard to think that actually the most effective way to educate is to get people to do things and to talk to each other and to even teach each other. So part of what I've been trying to do at the FJC in the last 3 years is to get that in our DNA, so that everything we plan starts with the assumption we want it to be interactive and participatory. And it doesn't mean we don't have lectures, because there are certain, as Brettel said, there are certain times and places where you do want to have mini lectures and times where you want to give people substantive information. And we heard earlier today some of those areas. Intellectual property wasn't mentioned, but it certainly is one for the federal judiciary, which is a critical area. It's very hard to talk about patent law, for instance, without doing some didactic presentation. All of the social issues that Chief Justice Russell talked about, the specialized courts, the specialized kinds of litigants, absolutely right. And you have to give people some information in addition to helping people with problem solving. I'm really looking forward to this. The 8th Circuit is having a workshop for its Article III judges next summer in Twin Cities, and we've been having some preliminary conversations about that, and it's quite likely that one of the main themes of the workshop is going to be dealing with mental health issues. As they come up in a lot of different places, in criminal justice and in the courtroom. I think that's really great. So there's an extent to which we have to think about those areas of substance. Then obviously in this area of social context, which I want to say more about, there is a subjective, experiential part of it, which is absolutely the core. That's how you open people's minds and get people to start thinking about it and integrating it into their perspective. But you can't totally ignore the information, the cultural competence piece. There's a certain amount of information you just have to have about people who are different from you. It's not enough just to have an open mind and be able to realize that the differences are there and that they're important, and you have to be aware of not only the conscious ways that they affect you, but the unconscious ways that they affect you. But there's also a place for narrative and stories and information. So there are places for that. But what I think is challenging me the most these days is thinking about where we started actually with the opening panel, and that is what makes it a good judge. And I don't think that there is a normative answer in the sense that we're going to say, well, that's it, and everybody should try to be like him or her. But I think there are some qualities, and I've written about this and I've talked about this, and I think that these general categories are still right. That one of the things is kind of a norm, sort of a baseline, is competence. But of course we have to define what competence means, but being competent is certainly one thing that we want judges to be. We want judges to have integrity, which is to say we want their decisions to be intellectually honest, in accordance with the law, not influenced by corruption and so forth. And we want judges to have an appropriate temperament, particularly trial judges who interact with the public all the time. Their temperament, the way that they embody our aspirations for the judiciary in dealing with the community is very, very important. And then I think within each of those categories, there are particular kinds of skills which may not be so obvious. And in the area of competence, sure, judges should know the law, they should be able to do legal reasoning, they should be able to write well, and express themselves orally, but beyond that, there are the whole issue of how do you deal with people? How do you handle people who are screaming at each other in the courtroom or are taking positions that are very adverse and not reasonable? How do you manage that kind of human conflict? That's a skill, and I think it's part of what constitutes a competent judge, is you're able to deal with that type of thing. Leadership, which we've talked about, is another skill set, and every judge, I think, in some capacity, is a leader. And there are elements of leadership that are part of the skill set of a competent judge. It may be that a particular judge at a particular time is simply a leader in his or her courtroom, but judges are leaders in their courts, they're leaders in the community, there are different skills that go with that. Listening is one that I really have been honing in on as such a critical one. Judges spend hours and hours and hours listening. But I'm not sure judges listen very well. We listen selectively. We're taught to listen selectively. Go back to law school, right? Spot the issues, apply the law. You know, that's not the same thing as really listening to somebody. It's not the same thing as listening with your heart and your ears and your mind. And what's that person trying to tell me? You know, what are they experiencing? It's deep listening is very different from the kind of listening judges are taught to do. So there's a lot within competence that I think is really worth exploring. Integrity, sure, at a basic level, you shouldn't take money to decide a case, right? You shouldn't ignore the law and decide the case the way you think it should be decided. There are easy, low-picking fruit kinds of examples of what integrity is. But it seems to me this whole topic of implicit bias and unconscious effects on decision-making, which was teed up in the first panel, I mean, that's all about integrity too. If you know, and we know this, and it's not even arguable, that the brain does not always tell us the truth. You know, our perceptions are not always accurate. People system 1 and system 2 thinking operate very differently. And if you think too much in system 1, you make perceptual mistakes. If you know that, and then you think about it for a few minutes, and you realize that doesn't just extend to whether you see the gorilla walking across the basketball court, but it also extends to when you see a person who has a particular set of social characteristics that you may have certain intuitive responses to that person. If you know that, then it seems to me part of integrity is figuring out how to become more self-aware about that. And to not that we can ever be 100% self-aware, but simply to improve our ability to slow our minds down, to be more mindful, to think more system 2 and less system 1 as we go through the day. So I think integrity has a lot of implications in this area. I found that, speaking of pedagogy, which is what our session here is about, talking to judges about implicit bias is very, very difficult. And that if you come at it, you all have implicit bias, and you better do something about it. If that's the way you approach it, you have lost them forever. And I remember thinking that when I started at the FJC, I was talking to people about this, and said, "Are you going to do anything about implicit bias? We don't have enough." And I said, "Yeah, I care very deeply about it, and we actually are going to do something about it, but you're not going to notice. It's going to be really, really subtle." And that's pretty much the way we've approached it. We've talked a lot about neuroscience, and we've talked a lot about the tricks your brain plays on you. And I think you get people to a point where they accept that that's being human. There's no blame. There's nothing. You don't have to feel guilty about it. There's no moral approbation one way or the other. I mean, it's just that's what being human is. And I always talk about Plato, Plato's Republic and the allegory of the cave. I mean, these are very old ideas. And the question is just how do we get better, right? Not we're bad and we need to do something about it. I mean, how do we get better? How do we become better decision makers with more integrity in our decisions? And then the last thing, I mentioned temperament, and I don't think temperament ever gets enough attention, because it's, we all have different personalities, right? And you have judges who are rough, and you have judges who are kind, and you have people in between, the one I was like, they don't suffer fools gladly, and everybody's a fool, that one. I don't like that particular kind of judge. But I mean, I think temperament's a hard thing to talk about. It's like trying to talk to judges about humility, right? And it's not one of our strong suits as a profession, for some obvious reasons. But it's still worth talking about. And where I found sort of an inroad into this, which I really have found very exciting, is in this idea of emotional regulation. And that is that being a judge is very challenging emotionally. I mean, I don't know any judges who haven't had a case where they had to sentence somebody and it broke their heart, or they haven't had a case where they were criticized publicly for something they did and they felt it was unfair, or they just got overwhelmed by their workload. But there's a tremendous amount of emotional strain in this job, and I think we've kind of attacked it in terms of attacking the symptoms. We've talked a lot about how do you deal with stress. How do you know when you're stressed out? How do you take more vacations? Meditate. I mean, these are all good things. I mean, I do as many of them as I can. But I mean, that's not totally getting to the heart of it. I think part of it is there's a paradigm, at least in the common law, that judges are unemotional, that we don't have emotions. I mean, we are deciding things based on the objective facts and the objective law. Well, I'm here to say that's not true. But the problem is we feel emotions, and we feel like we have to suppress them rather than acknowledge them. And I'm not sure, A, that that's healthy, B, that produces the kind of temperament that we look for in judges, and C, I think it does kind of work sometimes the justice we're trying to deliver. Sometimes it may be better to just sort of acknowledge the fact that, wow, I'm really angry. And what am I going to do with that? Am I going to take a recess and wait till it dissipates, or am I going to find some constructive, appropriate way to let people know that this is how I'm feeling? Or am I feeling this way for reasons that are not appropriate? I mean, it's just reminding me of something else that happened outside the courtroom that has nothing to do with these people. But I mean, it's going through the process of acknowledging where you are, being more self-aware. And I think this is newly charted territory for judicial education in most places, but I think it's really worth exploring. And so part of what I've been thinking about a lot lately is this worth talking about, and then how do we talk about it? And the place that we found a little bit of a opening is in the area of sentencing. That because I don't know any judges actually who've done criminal calendars who haven't at some point struggled with sentencing. That it's never that easy. That even if you are somebody who just kind of religiously follows the sentencing guidelines and you just sort of, I'm just doing my job and I'm just moving the merchandise through the court. You can't do that in every case, and there are cases that are going to tear at you. It could be a defendant, or it could be a victim, or it could be a situation. One that happened to me most recently was one of these mini Madoff cases where there were 30 or so victims who'd lost their life savings to a Ponzi scheme, and they came to the courtroom and talked about what had happened. And I just felt myself getting so incredibly angry, so angry, and I just wanted to throw those defendants out the window, And I had sort of, I'm feeling this as I'm on the bench. What am I going to do? So I think these are things that for us to talk about with our colleagues, and of course you have to do it in this interactive style. You can't lecture about it. You got to get people talking and telling stories. It's a tremendous challenge, but I think it's a challenge worth taking on. And to go to Livingston's point, which is what I'm going to close with, I think as we do this, as we get judges to be more self-reflective, more aware of what they're feeling, less guarded with each other about their experiences, I think that does several things. It helps you overcome your isolation. I think it helps you grow because you're more open to other experiences and some of these other narratives and more aware of your own thought process. And I think at the end of the day, you get better justice. I think you need to know what's going on out in the community to have a better sense of who's unserved and what are the experiences they're having. It's an inside-outside thing, but I think focusing on the inside is very much worthwhile and a really good task in judicial education. So that's my 2 cents. Thanks very much.
The panelists were so good that we do have a couple of minutes for questions, so we will entertain 1 or 2 questions if there are any.
So the event?
I have the.
Dennis and then.
Okay, so when I was a student, I really hated simulations and thinking about some kind of fake scenario, and maybe that was just me. But I've also found that at times our students don't think of them as very serious, and I think certainly for any judge who's a current judge has kind of 100 different real life situations in front of them that the learning could directly apply to. And so in thinking about, and I think Judge Fogel maybe kind of referred to this a little bit in telling stories as one way to get away from simulations and towards real life experiences. But I'm just wondering about, is there an education model that really can take advantage of what's really going on in judicial dockets?
What's implicit in your question, I think your point's well taken. I think the difference in law school is people haven't been lawyers yet. So, and there's a temptation. I have taught in law school, so I'm just speaking from my experience there. You sometimes will make up simulations to make pedagogical points, right? Or something's going to show up on an exam somewhere. But I know when we do a lot of this, and we will videotape sentencing scenarios, or we'll make up problems, we try to make them as relatable as possible. We might not be just an exact version of one person's case, but we will say, does this scenario tee up the stuff that people are concerned about? And so, one of the big concerns for judges in the U.S. is the mandatory minimums of drug cases and the sentencing guidelines of drug cases. We're having a terrible problem with child pornography cases because the guidelines are extremely punitive, and a lot of judges are having a hard time. So we'll set up fact patterns where it's a garden variety child porn or drug case, and then give the judges a chance to talk about it. But making it relatable, which is the thing you're getting at, is you got to do that for it to be good education.
Thank you. One more question, and then we'll close.
I was watching television last week, and surprisingly, they photographed a video of a courtroom proceeding in a capital case came on, and the judge was one of our judicial educators, great teacher, helping us organize a program on capital case training. And the defendant was screaming and yelling profanity at the prosecutor who wanted to be self-represented. He was yelling at the judge. And the judge, and the picture was from the back, with the defendant's back and the prosecutor's back, and the judge's face being totally unemotional, unresponsive. And the reporter, he was somewhat inferring that, yeah, that's weird. I mean, how do you sit there when someone is doing this and not respond? Now, he asked politely for the bailiff and the officers to, handcuff the guy and take him out. But it struck me that is weird. you know, and yet, you know, we have a sense that we can't really express our emotions, and I just, it goes to your point, I think that it's tough to, you know, on one hand, to try to be unemotional, but on the other hand, you know, to be a human being.
Yeah, well, you don't want to just lose it. I mean, that, you'll see that on TV too. Was it in Florida that the judge who said to public defender, let's just go outside and settle this? I mean, that, you don't want to do that. So it's somewhere in between.
Well, I guess one more we have to go. I think we have to go, so we'll take the question afterwards. Thank you so much to the panelists, and thank you to you.